All right. Well, speaking of cases that get appellate review, going from the Second Circuit, which is the New York kind of circuit, to the left coast, the Ninth Circuit, we did get a decision in the Yuga Labs versus Ryder Ripps case. And this was a mixed decision, although I think both parties found a way to say that they won the appeal. So that's kind of a unique thing here. And the court did two things. The Ninth Circuit Court, which is the circuit appellate court for California, said, one, there was some concern here, both among the parties and among the trademark lawyer bar, about whether NFTs are themselves actually goods that are subject to the Lanham Act. So basically whether they can be a good that carries trademark rights that you can enforce, or whether they're kind of digital certificates that don't have any meaning. You can't enforce anything against them. The Ninth Circuit ruled that NFTs are legitimate goods that can be enforced, and that trademark protection is available for NFTs and this industry. So I think that's great. I think Yuga Labs really set a precedent for the entire industry in getting this decision. Now, the second part of the decision was trademark law talks about consumer confusion. To establish consumer confusion, a plaintiff needs to there's called sleek craft factors. So it's a multi-factor test about how strong the mark is, how it's sold and what channels of trade, whether consumers are confused, and you weigh all these different factors. It's 7, 8, or 9 different factors depending on which circuit you're in, and the judge can decide whether it is confusion, not confusion, or something in the middle, and it needs to go to a jury to evaluate facts. Now, in the trial level, the judge said there is confusion. Yuga Labs wins. The appellate court said, there's some facts here I'm not quite sure yet. I'm going to reverse and send it to the jury. So Ryder Ripps won in the sense that it was not a summary judgment victory for Yuga. That victory was vacated, but it also was it's still open. Like the question of whether there is confusion has not been decided. The jury will now need to decide that.
I love it when you talk intellectual property, and you obviously know a lot more about IP than I ever will in this lifetime. But in a prior segment, we've been talking about, we want to foster innovation. Parody and satire is a form of innovation. You're kind of kneecapping that in some ways. Now, obviously, there are clear ripoffs of things, and those shouldn't be allowed. But is the Scary Movie franchise, which is a dated reference, sorry kids, but is that now illegal? Like, how do you know how expensive it is for people to go in court and prove that? And usually what you're doing is you're going after a big corporate behemoth that has all these resources to fight you, and you're just trying to do something funny. I have an NFT called a Peekaboo Punk, and it's a punk, but it's like off on the side like this, but it looks exactly the same. Like, am I going to lose that now?
Yes, Kyle, we're going to take away your punks.
Damn it.
That's it. ripping it out of your wallet. Look, I'm super sympathetic to this free speech
Doesn't sound
concept, at least in theory, and the idea that there's artists out there and they're having social commentary and they're doing all these wonderful things with their art. Now that argument, the trial judge was like, "Oh, not here. That's bullshit." And the Second Circuit also was like, "No, the free speech thing." The Supreme Court just decided that not going to fly here. So that was like thrown right out the courthouse in this case. But I like, there has to be room for parody and satire and critical speech and all of that. And I think this industry is actually pretty good at it. It enables like some pretty wild characters to do lots of fun stuff and to create like knockoff punks. That's all great. But there still needs to be ways for real companies to enforce their brands and to make sure that real consumer harm doesn't happen. And that's kind of what we're fighting for here.
Just seems like the line got moved a little bit, but I do like that NFTs now being classified as real property. That's a good thing. So
yeah, the trademark attorneys can do more work in the crypto space. So there we go.
Loves to hear that.